based upon the type of industry involved. Uh, so if you are failure to identifying the IP rights, so it will be creating problems for your startup business. Okay. So first thing is make intellectual property protection a priority. So prioritize your IP rights. Okay. Then you can evaluate. Then next is coming to register intellectual property rights. So certain IP rights like patents and designs, they are required to be registered before claiming any protection under the respective statutes. Okay. And on the other hand, certain IP rights like trademark and copyright need not be mandatorily registered for protection. Okay. So only thing the IP rights like patents and designs, they have to register for claiming the protection. Okay. But the IP rights like a trademark and copyrights, they need not be mandatorily registered. Okay. So, nevertheless, a registered IP right carries a greater value and acts as evidence of use of the IP rights before courts as well as enforcement bodies. Okay. So, you want to claim protection for these two only, patents and designs, industrial designs. But for trademark and copyright, it is not needed. Okay. The next coming to due diligence of IP rights. Due diligence of IP rights, already I have told, while you are starting up any venture, your startup, you have to confirm that it is not in violation of it is not in violation of IP rights of any other person. Okay, already I have shown you here. That is so that it will be ensuring safety. You can see here. That is in the first one, startup. While starting any venture, the startup also needs to confirm that it is not in violation of the IP rights of any other person to save itself from unwarranted litigation or legal action which can pervert its business activities. Okay. So first thing, due diligence of intellectual IP rights means you got to first need to confirm that it is not in violation of any IP rights. Okay, of any other person. Okay. Otherwise, your business will be collapsed. Okay. So that is this will ensure safety from unwarranted litigation or legal action which can pervert its business activity. Okay. So it is not in your startup needs to confirm that it is not in violation of the IP rights of any other person. Okay. The next fourth one is implement clear and effective policies and strategies for protection of IP rights. Okay. So here it is in the long-term interest of startups to have an intellectual property policy for management of various IP rights, which may be presently owned, created, or acquired in future by startups. So here, um, you have to you have to implement clear and effective policy. Okay, so it must be clear and effective policy. So that is which may be presently owned or created or code in future by startups. Okay. So what is the aim means? So the aim of such a policy is to ensure that there are no industry dispute between the promoters or the startups. That is between the two companies. Okay. So they are also producing that product. Other companies also they are producing the same product. So there should be no industry dispute between the promoters or the startups, which remains till date to be one of the main concerns for failure of startups. So if any this is arising, problem is arising, so it will be failure for other concern. Okay. So there should not be any industry dispute between the promoters of the startups. Okay. So we have to make implement clear and effective policies. Then next, agreements related to intellectual property. Okay. So here it is agreement is that is pertinent to note that having proper documentation in the form of agreements like non-disclosure agreements, agreements with the employees or independent contractors can make all the difference between the success and failure of startup. So we have to make proper documentation in the form of agreements. Otherwise, it will lead to it can lead to something. It will lead to the failure of startup. So first, the intellectual property is created usually. The intellectual property is created either by the founders, okay, or some key employee of a third party. Okay. So the intellectual property is so created must be protected through a proper agreement between who and who, founder or the key employee of a third party, as the case may be, and the startup. Okay. So here you have to the documentation must be in the form of agreement only. So So otherwise it will be leading to the failure or success of any startup. So that will be between the founder or some key employee of the third party. Okay, so there should be a proper, it must be protected through a proper agreement. Okay, and if the agreement with the founders or employees or a third party under which a novel idea was or is created is overlooked, it should create bottlenecks later after such idea becomes successful. Okay, so if the agreement that is you are putting with the founder or employees or a third party, some for some idea it is created means later time after the idea got successful, after that there the problems will be creating for with the founders or employees or the third party. Okay, so the startup needs to ensure that anything created on behalf of the startup, it belongs to the startup and not the employee or the third party. Okay, so previously the agreement, they have put agreement with the who else, founder, then there the agreement is with the employee or third party. These three are included, and your novel idea was getting successful, got successful, and it will be creating problem between these three founders, employees, or third party. Okay, so now we have to ensure that your startup created on behalf of the startup, that anything created on behalf of the startup and belongs to the startup and not the employee or the third party. Okay, and also you have to advisable to enter into elaborate assignments, licensing or user agreements, and care should be taken to make provisions for all post-termination IP right issues. Already I have told that um, you are the owner, you can sell or license the IP for commercial gains. Okay, so proper agreements should be there. So it is advisable to enter into elaborate assignments, license or user agreements. Okay, and you have to take more care for the provisions for all the post termination of IP right issues.